Hello, fellow toolboxers. Welcome to another popular episode of Kevin Gregg talking about court cases. It really is statistically one of the top
But
shows, so it's wonderful. Thank you, Kevin, for that. I don't know if you noticed one of the recent episodes I started calling you the Honorable Kevin Gregg because at this point you almost are a judge, and he's audio. Is
don't
he feel free to talk? No one can see you in the video, but Honorable Kevin Gregg. I'm going to call you that for
don't
now.
don't 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 don't.
Too
I gotta
soon.
put a stop to that. I didn't hear that. I'm not a. You gotta stop calling me the Honorable Kevin Gregg. I respect the judiciary too much.
Okay, I like to say a lot of stuff. Okay, we'll keep it at that. But before we start, first off, this is not intended for individual legal guidance. Please consult with an attorney about your case. We have a great free CLE talking about abandonment of status with Joseph Sang for members of the community on circle.so, Toolbox community. You can just see it there free. It's free for other lawyers too. Just email me with your bar info and your email you want to use in your name, and I could add you to the community page. We got like hours and hours of free CLEs on different topics that could help you. And also, if you want to make the switch to U.S. immigration law, you want to have some videos, materials, trained staff, we have this called the Ultimate Marriage Green Card course, which was a live course recorded, broken down, edited. I think it's like 18 hours of stuff. And plus, there's office hours every month. The course is really the best thing out there. Learn basic family-based immigration law. Basic, I mean a lot. The consular processing, adjustment of status, basics of inadmissibility, 212, 245I. We go through the statute and regulations, the real way to learn immigration law, plus all the practical stuff of me telling the real stuff of what's going on. Go to the website of the course. We have videos of people who love it, started practices based on it. And so it's really special thing. I want you to join. If you want more info, email me at info@immigrationlawyerstoolbox.com. But having said that, let's get the great show started. Again, with the it's not the non-honorable Kevin Gregg. You got to be the honorable or non-honorable. So which one is it?
I have honor. I like to think that I'm honorable, but I'm not the honorable. You can say the Kevin Gregg who has honor. Actually, that might be a problem too, because again, there's the other Kevin Gregg, and I don't want to imply that he doesn't have honor. That's Kevin Gregg Kevin A. Gregg will be fine.
Our good friend Kevin Gregg, partner at the Encouragement, Ted Zelli, and I just interviewed him. I can't forget Tezelli and not
I
Frank,
can help you
Tezelli
out.
and Pratt law firm.
If you can get past Tazelli, you're usually in the clear. That's why I'm surprised. That's the one that holds people up. It's a hard name.
Yeah, but she's a great lawyer. I really enjoyed her interview that we had. If you haven't,
Oh yeah.
Tezelli's the later rate. So I really enjoyed interviewing her. Actually, I think she started her own podcast, didn't she?
Well, no, I mean Helene and I, we're now trying to start it off with the firm that I'm actually. Her and I are having a discussion every so often about trends, and Helena. I mean, Helena is a great lawyer. She's primarily in business immigration and then business litigation in general, not even immigration, as you know from your interview. But also like Helena, she might have said it on your show. She definitely said to me, Ira has called her like a Swiss Army knife. Like, is that like a weird thing? It's not even research all the time. Like, how do I get this Bosnian individual a consulate interview in the Czech Republic when he's got like a step, like all these things that just like let's Helena will find the answer. And it's
Yeah.
pretty remarkable. As is Carl Rich now with our firm, who he's the consulate whiz, but you've interviewed the whole firm at this point. But I mean, I always tell people to reach out to you to get interviewed on your show. You've got a great show going on, John.
Appreciate it. Thank you. Yeah, I've been working hard I've been sitting down, catching up a lot of work, and it's hurt my back from sitting down too much. So
Yeah.
I got to figure that out. But I caught up with a lot of backlog of 10 months of work and videos. And you might notice I told my assistant not to email you when we're posting stuff because you have a backlog of Kevin Gregg videos that are being posted.
Yeah, you've been blasting. I have seen you've been blasting it out. I want to be like, that's a lot of me. I hope people aren't getting sick of me. That's a whole lot of me.
We're almost done with the backlog. So it's 2 more months, I think, of Kevin Gregg plus this one right here, and then we'll be caught up. I don't want to tell you, like, record all this video, and it's not going to be posted. Sorry, I'm catching up. The
Yeah, I
backlog
mean, right. Okay, so it wasn't. I thought it was. I figured it was reposting. So they just never posted it. That's what
Yeah,
I
there
thought.
was like 10 videos and interviews that were just caught up in
Wow.
the library. And I used to record the intro separately and then have them edited together, which create time. Now I just do them live, so that's why I just get it out because if I have to have the team edit it, then it goes in the back burner and then I got to catch up. So it's too hard to do that.
Well,
You know
that's
more than
what
anybody of editing. Your video is highly polished and
I
formatted.
do, but I must say, I got you in my calendar. I come in on time, and little did I know that you just haven't been posting for 8 months.
I
I
shouldn't
feel
have
a
said
bit
anything.
betrayed. Feel a bit betrayed. Well, okay, so in that case, it's good to talk to everybody. Yeah, I presume it's February 2025. I hope that the country still exists. If
Well,
that's
add
what.
insult to injury. Like we rescheduled this. We have another live show in 20 minutes. So now we have to push
Wow.
everything out 20 minutes. Might be reschedule our time so it won't be so pushed in. But I guess we got to kind of jump into it. But hopefully this get posted. We're not blowing up because the recent events we're recording is August 6th. It looks scary, but hopefully it's just one of those blips in history.
That is insult to injury. So let's get to it. This is, of course, the August recording, meaning it's the July cases. And the first one is the Great Azuma v. USCIS decision out of the Fourth Circuit. If it's a great win out of the Fourth Circuit, there's a good chance it's a Ben Winograd win, which this is. Guys pushing the law forward in that circuit, especially. Ben has tempered my excitement of this decision, and it is his decision. So, he's a good lawyer. It's probably right. But I will say, if you've ever had the disastrous case of trying to naturalize somebody, and USCIS can come back and say, despite them being a green card holder, we don't believe they've been lawfully admitted for permanent residence, such that they can naturalize. Maybe they find that they didn't disclose a criminal arrest in their green card application, or that USCIS made a mistake. They can come back and essentially, as you know, do full-on LPR adjustment inquiries at the naturalization stage. And not only might they deny naturalization forever, right? Because you're never going to then fix your unlawful in their terms entry, but like they could file notice to appear, try to remove you. Now, a lot of that comes down to USCIS's own regulation. It's 8 CFR section 316.2b. The statute itself just requires, and I want to do the quote, that the non-citizen who's applying to naturalize have been, quote, lawfully admitted for permanent residence, end quote. And that term is defined in INA section 118.20. So USCIS, in requiring something more than just having LPR status to naturalize for 5 years, has added a requirement not contained in the INA, that not only you have LPR status, but like that LPR status was completely correct and there's nothing possibly wrong and you have to meet substantive requirements. That's the argument. Been making that argument for a long time. A lot of people have who get caught with this, and well, Ben just kind of won it. Mr. Azuma, it's a bit sui generis of a case. Mr. Azuma had LPR status. I think he got some conviction, which they believed was a CIMT, left the United States. And because of that, when he tried to come back in, DHS charged him as an applicant for admission and put him in removal proceedings. Very dangerous, because now he's not even being treated as a LPR. He's being treated as an applicant for admission. But then, with the agreement of ICE, those removal proceedings were terminated. Prosecutorial discretion, who knows, whatever. Removal proceedings are terminated. And so he applies to naturalize. Still an LPR, right? Has had it for more than 5 years, all those requirements. USCIS got real cute, though, and said, no, because you are still being treated as an applicant for admission. We're not treating you as an LPR because, you were an applicant for admission and that was never resolved. Like the proceedings were simply terminated. Your last entry was not as an LPR. It was as an applicant for admission, is what USCIS said. It's not crazy. It's just a very unique fact pattern. But the Fourth Circuit says, no way. Like, the regulation, again, USCIS regulation requires, quote, that the applicant was lawfully admitted as a permanent resident of the United States in accordance with the immigration laws in effect at the time of the applicant's initial entry or subsequent entry. All of that is more than what the statute requires. The Fourth Circuit held, quote, lawfully admitted as a permanent resident for naturalization is simply clearly intended to reference the substantive requirement of LPR status found in Congress's naturalization statutes, end quote. Nothing more. To naturalize, you need to be an LPR. You just and not have lost it, at least in this context. I mean, are you following? It's a I mean, I know you're following, but I don't know if I'm describing
No,
it.
I'm kind of lost, but
Right.
I mean, wait,
It's
so they're saying they are LPR even though they were their thing for admission, or
Well, he was always an LPR. You're an LPR until an immigration judge, and then the Board of Immigration Appeals, if you appeal it, says you're not. And so, despite him being treated as an applicant for admission at his last entry, the Fourth Circuit says no, he's an LPR. There's no more analysis required, USCIS, for him to naturalize. Your regulation is adding additional requirements. That is, that everything be perfect, that he was admitted as an LPR at his last entry. None of that is in the statute. All that's in the statute, to paraphrase, is that you've been an LPR for 5 years. And so, Mr. Zuma is going to get to naturalize, it seems. Ben is tempering my enthusiasm, saying this might be is probably just specific to this unique case in which an LPR leaves, comes back, and is treated as an applicant for admission because of a criminal activity, and then that's never resolved. But to me, the logic that the Fourth Circuit is using, that is that USCIS's regulation about naturalization requirements to mean more than just holding LPR status, that is ultra-virus the statute. That is the logic the Fourth Circuit is using, that USCIS's reg at 316.2b is adding a requirement to naturalization that Congress did not see fit to make. And if that logic is employed, that would mean that USCIS's reg and what USCIS does when you apply to naturalize is wrong, that they shouldn't be looking into whether you got your lawful permanent resident status completely correct in accordance with the law. Like, maybe you needed a waiver and didn't get it, and we think you needed a waiver now, and so we're going to deny naturalization. Or, maybe we didn't, even though we thought at the time that you were the unmarried son of a U.S. citizen. Now, when you got your LPR status, now we think you were actually married, so we're denying naturalization. That entire analysis, to me, I believe, is dependent on USCIS's reg at 8 CFR section 316.2b. This decision really seems to imply that that's not a proper regulation. They don't go that far, but I don't see how you read it any other way.
So I have that fact pad on a console on the marriage one, and I just threw out, well, Nats, they'll deny it and potentially send you to immigration court, which they probably won't, but they said then you do 237A1H, you fix it, and then you just come back and get it. That was like standard operating procedure. But one thing is, I just popped in my head, one is, does revocation, the 235A1 is off top, but 237A1H apply if there's revocation, the darnest statute ever?
I don't think so. Which is why you should never apply to naturalize if there's any issues, if it's not within the 5 years, because USCIS can't revoke, obviously, after 5 years. Look, there is the caveat. It couldn't happen here, right? Because DHS agreed to terminate. There is the caveat that even if I'm right about the regulation and this whole analysis being improper, USCIS can always NTA you, and then you got to go to immigration court. Like, no part of this decision is saying that they can't do that. They couldn't do that to Mr. Zuma because, again, he had already been in immigration court and it was terminated. But if they don't, they can't just deny based on a finding that you shouldn't have gotten LPR status in the first place. That is the argument. I'm not saying this decision necessarily holds that. I'm saying that I don't see how they get to their holding here without implicitly and almost explicitly saying that 8 CFR section 316.2b is doing something more than Congress's statute, which makes it ultra-virus and improper.
Wouldn't they go back to or just say it's bad moral character or something like that?
Within 5 years? I mean,
I mean, they could go out nowadays. They go outside the 5 years. The policy
I
is
mean,
like
it depends on the facts. I mean, it depends on, like, don't get me wrong, there's ways around it. But the core thing that at least we see, because people come to us with unique issues,
yeah,
is USCIS making that finding. We're denying your naturalization based on a finding that you were not lawfully admitted for permanent residence, emphasis on lawfully, when you got your green card. And that's based on 316.2b. That's the regulation that permits USCIS to do something like that. And again, seems like the Fourth Circuit is saying that regulation, that's a little too cute,
yeah.
is the
Well, it's
argument.
one of those where USCIS would want to probably follow up and try to push the issue. But hey, it's a win. It's interesting fact pattern, and it's
Azuma
cases
v.
that I'm going to deal with. So
USCIS.
I just want, my ears are open on this one. Like I have, this is stuff I have to deal with.
Pin it. I mean, yeah, you don't ever want to be in that situation, but if
Yeah,
clients come to you after they've already applied to naturalize, then you have to start, of course,
yeah,
making that. Azuma's, it's unique. Be careful, read the decision. It's unique. We've only got 20 minutes, and I'm counting it. We're at the 16-minute mark. So I
yeah.
don't even know what to do. I'll go through it
If you go
quick.
over, it's okay. The live studio could wait. Yeah.
Well, I only actually had well, I do have three more, but I'll go quick. First, the Ninth Circuit, which I always like to talk about on your show because you and I are both Ninth Circuit practitioners at the end of the day, although I span the country, is Shen v. Garland from July 24th, 2024. It's an adverse credibility decision. A lot's going on. Ms. Shen alleged she had claimed that she had a forced abortion and that it all came out because she went to go get a marriage certificate in China and she had to do a pregnancy test. And to get the marriage certificate, she had to undergo this test, and they found out she was premarital pregnant and forced abortion was the claim. The immigration judge found her not credible for a variety of reasons. But the BIA only affirmed on two of them, meaning there were only two reasons up before the Ninth Circuit, importantly. One of them, the Ninth Circuit didn't believe all that important, so we're down to the last one. The last one being this. On cross-examination, DHS, the ICE attorney, was saying, isn't it true that, I want to say it's in 2003. Isn't it true that in 2003, the year that this marriage appointment to get a marriage certificate happened, isn't it true that China changed the law and you didn't have to go to an appointment like this anymore to get a marriage certificate? And Miss Shen, she was kind of flustered, and I mean, clearly it was not doing well, and she was nervous, clearly, and said, oh, you're right, I'm sorry, it wasn't required. And so that the immigration judge really picked up on this and didn't like that she was inconsistent about implying that she had to go to this interview, to get the marriage certificate that resulted in the abortion, and that then now she's saying after cross-examination it wasn't mandatory. Query why it matters, because she still had a forced abortion is the claim, but put that aside. But the Ninth Circuit did its own analysis, its own legal research into foreign law, and found that actually the change in law in 2003 happened, I want to say, like in October. So months after Ms. Shen went to it. So it wasn't the case that China had changed the law at the time she went to this meeting. And so this is what's important. So the Ninth Circuit says DHS was improper in its cross-examination, and the immigration judge was improper to believe that was inconsistent, even though Ms. Shen was kind of inconsistent when confronted with it. And to me, this means this. Cross-examination in any court in removal proceedings is the worst time of any attorney's life, because they're just sitting there, mostly helpless, as their client just gets wrecked. Now, you prepare your client the best you can.
Yeah.
But ICE learns how to cross-examine. You are not powerless, though, and we have all of the objections that are given to us under the federal rules of evidence. And the Ninth Circuit here, for Ninth Circuit practitioners, is saying ICE can't cross-examine just by making stuff up. I don't think ICE made up this. I think they were just sloppy or didn't care about what month in 2003 the law changed. But if counsel had known what month the law changed in this case, counsel could have objected to the cross right then and there, and that should be sustained based on this decision, Shen v. Garland. ICE can't cross based on made up or incorrect information. And with any cross-examination, and certainly ICE, I've seen it, sometimes they're just a bit sloppy in their facts, seeing what the non-citizen will say. That's on the line. Is that proper cross-examination? There's a lot of leeway given on cross-examination. It goes both ways. But, rein them in. Objection, facts not in evidence. Objection, misstating the record. Or in this case, objection, making stuff up. In any event, this is an important decision, Shenby Garland, for many reasons, but for how to defend your client on cross-examination.
And another thing is just knowing the facts. Like the lawyer has to know like country condition facts that those change in the specific months.
Absolutely.
Look at the year or two and assume that.
But to be kinder to this attorney, I mean, that's a
hard one. Yeah,
that's a hard one to know. To come into immigration court knowing that a change in law happened at all about having to go to a marriage interview in China, and then knowing the month. That's a hard one. Don't get me wrong, but
I didn't even know you have to do his registration until now, because I remember they changed it, the one child policy to 2 child, and the village is even more. But I heard that in the news. It wasn't like to go next. Yeah, no shame to that person, but it just that's goes to show you asylum lawyering is not just copy paste in the same application with a different name. You really have to know each person's facts, because it's so hard. You have to really know the country.
I'm not aware of any asylum lawyering like that, and people who do asylum lawyering like that are they're not doing good lawyering.
It's tough. That's why I don't do it. It's too much. It's enough. It's commemoration. I don't do all the stuff you do. It's too much studying. It's way too much.
Yeah. The last two, then, I'll be real quick. Pay v. Garland out of the First Circuit on July 17, 2024. This one, the holdings aren't that much, but this individual fled as a child from the genocide in Sierra Leone. Yeah, from Sierra Leone. And he gets injured outside of Sierra Leone, arguably by Sierra Leone forces, but he's fleeing ethnic cleansing and genocide in Sierra Leone. As a child, comes to the United States. I think he gets LPR status, if I'm not mistaken, and then he gets in trouble. Right. And this was remanded back to the BIA, and so there's not much law here, but for the BIA to determine, is flight from ethnic cleansing and genocide past persecution in and of itself? And that's an interesting issue. I wish there was more analysis here. We'll see what happens on remand if it comes back. But, asylum was created as a response to the Holocaust. And so it can't be the case, as many circuits have said time and time again, that you have to suffer terrible harm to get asylum, to be a refugee. You don't have to get almost killed. It was designed to protect people fleeing ethnic cleansing and genocide. Maybe it was because that shows a well-founded fear, but maybe fleeing genocide in and of itself is past persecution. That's now before the BIA after a precedential First Circuit remand, and I'm excited to see what they hold. So, wanted to note that. And the final one, also from the First Circuit, before I let you go on your own show, is Cruz Galicia.
Show, advertise a little bit on your, come on the live show too and take questions.
Cruz Galicia v. Garland out of the First Circuit on July 1st. This is a total loss for the non-citizen. Don't want to even get into it. But the purported particular social group brought up by the non-citizen was climate refugees. Now, as I said on my show, I don't love that group because putting refugee in the particular social group itself is defining the group by what you want it to be. I mean, you want to be a refugee, right? That's why we have a particular social group. You can't define a particular social group by using the word refugee. But that might be a bit pedantic. It wasn't succeeding here, but maybe we will see more climate refugee cases in the coming years. Are climate refugees people fleeing their country because of the dangers put on them by climate change and the government's inability to protect them? Is that a viable thing under asylum law? I don't know, but we are entering that world. And so this is the first time I've seen anything close to this on the podcast in 4.5 years. Climate refugees. Yeah. First Circuit denied it very succinctly, but maybe there will be more cases.
Very cool. Tell us more about your podcast. What is it called and where can we find it?
Oh, Immigration Review. Every Monday, all the cases. found
We have like
everywhere.
we have 1 or 2 minutes. Um what is things that have happened because of having a podcast that you did not expect when you originally like got it, started it? It's just things out of nowhere, like that were really cool.
Oh my god! I mean, first of all, what did I think would happen? That it would be that it would become popular. That's the start there. I remember like my wife and I looking at the statistics of the downloads in the first month and like having this huge celebration when we got our first download, and then when we got 1,000 downloads like in a month, we couldn't believe it. And now it's like, well over 1,000 in a week, sometimes in a day. Sometimes, I mean, it's so the fact that it would become popular in and of itself is a giant shock. But I've been most happy about how it's allowed me to connect with the immigration bar and for them to connect me. I mean, I get emails from listeners all the time, and not all of them are attorneys. And so that has become that I didn't expect that. I hoped that it would make me known, and it has in many ways. But to the extent that people not even about business, maybe they have questions, maybe they just want to talk. That has
Yeah.
been a surprise, and it's been really cool. Have you found the same thing?
Yeah, I mean, the one is the listeners. We have like consular officers that listen to the show, active
Yeah.
consular officers. So I got to be careful with the stuff I say. But other than that, it's just the celebrity aspect of it was like when I'm ALO, I'm like a rock star over there, even though it's just like for nobody at the conferences. So that's a lot of fun, especially because then you sit and talk, and everyone's like really open to talk with you because they trust you, and so
Yeah.
like you make really good friendships. So that's really satisfying. Of like because you and I love talking about immigration. Like it's a weird thing really into. So you find people are really into that too. And it's like, oh, great.
Yeah.
Like this is wonderful. Like I developed a community around it.
In addition to I'll tell you this, in addition to summarizing the cases, I mean, I put a lot of effort into this podcast, as you know.
Yeah.
It's not just the editing. Every one of these cases, every one of them has attorneys representing the non-citizen, attorneys representing the government, and immigration judges and BIA members who had done it below by definition. Some of those IJs and BIA members listen. Some of those respondents' attorneys listen. Some attorneys at OIL listen. And even if they don't, it's important for me to do justice to everybody and I don't want to make anyone the bad guy,
Yeah.
but also I want to be entertaining. More often than not, the BIA is the bad guy, just because in order to get to the circuit, you have to have lost before the BIA. And if you get a remand, that means the BIA was wrong, says the circuit. So, sometimes the BIA can be the bad guy, but I do know that they understand the game of it.
A perfect time when I'm not sure if out. So sorry about it. The BIA what it cut out right at the punchline.
Oh, what was the punchline?
I don't know what the last thing you said.
Oh no,
It
I
cut
mean
out.
the BIA knows the game. I think the BIA listeners know the game of it, and I've heard that there are people at the BIA who listen because, at the BIA you have to know the case law in all of the circuits, right?
Yeah.
That is a hard thing to do, and so of course I'm sure that BIA staff attorneys, BIA members, all of them, I'm sure they read the cases, positive.
I
But
mean,
like,
if you
if
want the
I identify
EOIR,
things for them,
should be listening. It's like mandatory listening to your specific one because you go into so much detail. I'm always surprised that you remember the facts. I'll read cases and I can't after reading it immediately, I can barely tell you what the facts were other than my own impression. Like right now in the show, you go over facts from like a week. You read it a week ago. I'm like, oh my god, this guy's got photogenic memory, photo something memory,
photosynthesis.
photosynthesis memory. Yeah, so it's amazing. Yeah, I would imagine if you're BIA or EOIR, like you have to listen to Immigration Review podcast because like you got to stay up on all this stuff and you just do the hard work for them.
Maybe. I mean, I'm not biased in how I'm telling the cases, but of course there
Yeah.
is a non-citizen's lien, and maybe that gets a little annoying. I must say though, not to show the man behind the mask, but like I have an outline for everything. I have an outline right now on my screen, John. I'm not just remembering the facts from memory. Now, when I start getting going, then some of it is. I remember that case again because I read it, then I recorded it, then I edited it, then I gave it a final listen. So I've done it like 4 times by the time a podcast is issued. But my outline from my podcast, I'm looking at it right now, and it's actually my podcast outline is 23,000 is 2,300 pages. and is
Just loading that probably takes a while on the Word
it's
document.
993,000 words. And before your show every month, I give just like a mini one. I take 3
Yeah.
cases or so and I put it in a document. So it's not all just me remembering, but I do remember cases a lot better now than I used to before I started doing the podcast. No doubt.
I'm having flashbacks of law school and outlining, which I always hated to do. And I
Yeah.
barely got those simple cases. I barely outline, let alone do all you're doing with it.
I didn't love it either. And here I am doing it. So I don't know. I can't explain it.
I always say if I had the work ethic I had right now 5 years ago, I would have been a gazillionaire. And I was like, if you did what you do right now with the podcast, probably in law school, you probably would have I know you probably were the top student in class. I'd imagine
I was
you just
not. I
learn
was
to
not.
work harder as you get older. So
Well, it's easier. And Ira says this too about, reading. Look, I've read for the podcast, I don't know. I've read 2,000 cases, 3,000. I have no idea. And Ira, of
mhm.
course, been doing it for 40 years for his book. You start reading them more. I'm always looking for the nuggets, but like there are parts that you can skim over that, like, okay, they're just saying the same thing for the millionth time.
Yeah.
So reading a case as an immigration attorney who's been an immigration attorney for almost a decade, I think that's very different than a law student doing it who's always entering law for the first time. I mean, every case I read, I'm pretty familiar with what's going on. So I think
Yeah,
that
the
makes it easy.
statutes and already, yeah, it's
Yeah.
not fresh, that fresh. Well, thanks. I learned something I got to remember for a case I was consulting on about the 237H and revocation, running how to add some extra follow up to a consultation. Revocation is so annoying. On the to-do list of things that like people want immigration reform, but what I want is getting rid of immigrant intent nonsense, and dual intent, all that kind of stuff, just making it easy for people coming on immigrants. Another one is getting rid of revocation, the really stupid statute. This stuff's not the sexy stuff about immigration reform they talk about with regard to people DACA or whatever, but that's the kind of stuff I want that's like necessarily
Yeah.
harsh and problematic. I remember I forgot about the old revocation out there, but
I think
thanks.
that if there's revocation, you're automatically in rescission proceedings in immigration court. Like that's what happens. Can you
Yeah,
file a 237A1H in rescission proceedings? Almost positive you can't. But
you
in the
can or
Ninth
can't.
Circuit, you cannot. But in the Ninth Circuit, you'd have a better shot than anywhere else because of the Ninth Circuit's. Oh, I can't remember. It's too bad. But they're
If
the
it
only
pops up, I know
ones.
where
And
to send them to. But yeah, I was happy. I'm like, well, let them just continue court, and then we'll do 39H. I'm like, oh yeah, it's rescission. Like that I became called revocation. Rescission,
yeah.
ridiculous statute. I
The
hate
Ninth
it so
Circuit's
much.
the Ninth Circuit's the only one that allows you to do a 237A1H waiver on an I-751 when it's a joint petition. And I can't remember the name of the case. The BIA just issued a decision saying that's not nowhere else can we allow that. But honestly, Loper Bright vacated Chevron. Like it doesn't matter that the BIA has said that nowhere else. It matters to the immigration judges, but not to the circuits. That argument should be made everywhere, and the Ninth Circuit's already ruled. And so if the Ninth Circuit has ruled that you can do it for a 751, maybe you can do it in rescission as well. I'm not bullish, but that is the last thing I ever wanted to say. I mean, you always want to talk. You're always wanting to talk about. And actually, I'm on gabapentin right now because I'm in a lot of pain. I actually got shingles. Crazy, right? And that actually makes me slower. So I apologize that I can't remember all these right off the
Wow,
top of my
shingles
head.
horrible.
But you always want to talk about the decision about, with a 245C and 245K, a matter of LK for
Yeah.
that. Chevron's dead. Matter of LK is owed no deference in any circuit. That argument is off to the races.
Matter of LK was BIA though, wasn't it? BIA, it was BIA basing it upon.
That's what I'm saying. And then maybe the implication from LK. My point, Chevron depth, the BIA is interpreting ambiguous statutes in
Yeah.
matter of
True.
LK.
Yeah. Yeah.
They said
I didn't
something in
think about
matter of
them as an
LK.
agency, but yeah, because yeah, you're
To
right.
the
Yeah.
extent that that was bad for non-citizens, that no longer is something that circuit courts can defer to. They have to do the analysis in their own right
Oh yeah,
every
like it's a
time.
reasonable analysis. That and
So
for EB1s, the ridiculous what's the one for EB1A? You have to do Kazarian analysis. Oh, that one I can't wait to knock that one out.
for any, but I mean, careful what you wish for. Maybe the circuit does an even more non-citizen adverse ruling. But I mean, the point is, like, nothing can be taken for granted anymore after the Supreme Court vacated Chevron. with immigration if you're willing to go to the circuit. If you're only willing to take it to the BIA, then yeah, you're stuck with BIA decisions. But if you're willing to go all the way to the
drawn out
circuit,
fight, but yeah, we'll get it there. All right, I'm not showing my video. Well, I appreciate it, bro. Thanks for coming on. We'll have to reschedule our time a little bit so we could have more open discussions like this. But I'll reach out to you. Thanks for coming on again. Appreciate it.
you're the master. Let's see when it gets posted.
It'll probably be out in a week or two. All right, brother. See you later.
Bye, John.